We'll just give it another minute as people are being let in. Good afternoon, everyone, and welcome to today's OC3PR. Today's session is going to be building on our previous session where we discussed some of the challenges experienced in critical care units with patients and their families in situations when benefits for ongoing care in ICUs is questionable. We will be discussing the role of the Consent and Capacity Board, often abbreviated to the CCB in Ontario. OC3PR, for those who are unaware, is a webinar series provided by Critical Care Services Ontario that tries to assist healthcare professionals along with other members of the hospital teams improve the care they provide to acutely ill patients. It provides best practice strategies and information on available resources, all with the intent to improve our healthcare system. As before, we ask our listeners to please keep themselves muted, but there is an opportunity for them to submit questions, which today will be fielded by Dr. Jennifer Tsang and Dr. Bernard Lawless, both members of the OC3PR Executive Committee. To submit a question, please type and send them to one of the individuals named Q&A for question and answer. This webinar, along with previous sessions, are available on the CCSO website and the YouTube channel. Finally, at the end, please take the time to fill out the survey because your feedback is greatly appreciated and helps us plan future events. Continue to look for other webinars on the CCSO website and their YouTube channel. Critical care units, by their very nature, is where the sickest of the sick are cared for. Advances in technology have been substantial, and we have been able to keep patients alive that previously would have succumbed to their illness or pathology. An unintended consequence, however, of these advances is that at times there are patients who end up in situations where the benefits of continuing such care is questioned by many of the highly dedicated health professionals caring for them. When the goals of patients and their substitute decision makers come into conflict with the care providers, there are many adverse consequences, including considerable moral distress on staff, which can be profound and potentially have long-lasting adverse consequences. Although ideally these situations are resolved by discussion amongst all parties, occasionally an impasse is encountered. An option to address these scenarios in Ontario is the Consent and Capacity Board. Unfortunately, many physicians and health professionals are unfamiliar with the CCB and how it works. Today, we'll be discussing the CCB, and we're fortunate to have with us a physician who has considerable experience with CCB in terms of both critical care, but also general internal medicine. Dr. Gianni D'Egidio is a critical care physician and internist at the Ottawa Hospital. He did his residency training in internal medicine and critical care in Ottawa and received a master's in mechanical and industrial engineering from the University of Toronto in 2013. He is the present program director for critical care at the University of Ottawa. He also helped co-found the advanced care planning team at the Ottawa Hospital. He has participated in over a dozen CCB cases and has amassed an unprecedented experience in these difficult and challenging situations. Our objectives today will be to explore the role and structure of the CCB. We hope to better define and explain the role of substitute decision makers. Finally, we will be exploring how to navigate the CCB process for physicians, health professionals, and organizations. Gianni, thank you again for taking the time to discuss this topic, and I look forward to your presentation and the discussion afterwards.
Thanks, everyone. It's an honor to be here. Thanks for the introduction, Dave. So as Dave kind of mentioned, I want to describe the structure of the Consent and Capacity Board to everyone, what it's made up of, and how it proceeds with its hearings. Also describe the role of substitute decision makers that's laid out in the Healthcare Consent Act of Ontario. We'll focus in on that because that's how the CCB makes their decisions. And then explain how to navigate the CCB process for the entire healthcare team, because this is not just a physician that is involved. I've actually had cases, and I'll speak about a case today, where it wasn't only myself at the CCB, but I had to have witnesses. And one in particular was a ICU bedside nurse and our dietitian as well. So it affects the entire team, and usually our social worker is involved quite heavily in the entire process. So as mentioned, I'm going to be talking about a case. For those of you that are unfamiliar with the CCB process, it is actually public knowledge. Anybody can attend a CCB case. When I was doing this, and as David mentioned, I've quite a bit of experience with this. This was both pre and after COVID. So pre-COVID, the consent capacity board would come to wherever the patient is, and it's an open hearing, so anyone can attend. I don't know how it works now in terms of attending the hearing, but the hearings are mostly virtual now. And if you'd like to see any of the reasons for decision for any of the cases, you can access the website for Canadian Legal Information Institute, and you will actually see all the reasons for decision. And you simply go to the website, you can type in my last name, and the reasons for decision will come up. All right, so here's a case presentation, and I'm going to try to refer to this throughout my entire presentation. And if I forget to, I've actually got a slide at the end as well that I can refer to. So we have a 62-year-old female here in Ottawa with Down syndrome and advanced dementia from a long-term care facility, admitted in September of 2018 with respiratory failure on the background of asthma and previous asthma exacerbations, who unfortunately required intubation in the ICU and a subsequent tracheostomy and had recurrent admissions to the ICU for respiratory failure. And family wants everything done based on religious beliefs. So we can definitely sympathize with that and understand that from a family perspective. However, at the same time, the entire healthcare team feels as though the patient is suffering. Recurrent episodes of respiratory distress, skin breakdown, tracheostomies can be quite invasive and painful for patients. The patient was incapable at the time, and we will be focusing in on this because the role of the CCB is not only to help decide whether or not the substitute decision makers are acting appropriately, but their primary role as well, for a substitute decision maker to be enacted, the patient has to be incapable. So we'll talk about that as well. And in this situation, the substitute decision maker or makers are two of the patient's sisters. All right, so as mentioned, we from the healthcare team felt as though the patient was suffering, and given her advanced clinical situation, both with her Down syndrome and as a result of her Down syndrome, her advanced dementia, we felt as though ongoing life-prolonging treatment was not indicated. Now, physicians must obtain consent in order to withdraw life-sustaining treatment. We cannot make a unilateral decision to withdraw life-sustaining treatment, and I've referenced that from a Supreme Court of Canada case from about 11 years ago. So if we as physicians cannot get consent from either the patient or the substitute decision maker with regards to the life or withdrawing life-sustaining treatment, we need to potentially engage in the conflict resolution process in the CPSO End of Life care policy, where we would file an application to the Consent Capacity Board of Ontario. So this is different. So withdrawing life-sustaining treatment is different from not offering it in the first place. So for those of you in the crowd who are familiar with recent case law in Ontario and the CPSO End of Life care policy, it has relatively recently changed, where physicians do not require consent prior to withholding either CPR or the bundle term of resuscitation, which includes an ICU admission, and we don't need consent to withhold that. Physicians are only obliged to provide CPR in accordance with the standard of care. And I'm not here today to get into the discussion of standard of care, but just to separate those two things that are different. Withdrawal of life-sustaining treatment is different than not offering it or initiating in the first place. So that brings us to the role of, or the structure and role of the Consent Capacity Board of Ontario, or the CCB. So it has the authority to review the refusal of substitute decision makers to consent to withdrawal or withholding treatment. It is a relatively rapid process compared to the Superior Court of Ontario. So if I file an application, which I'll talk about later on how to do that, usually you'll actually get a pre-hearing within 7 days of the application. And as mentioned previously, pre-COVID, it was done in hospital or wherever the patient is located. And now it's done virtually and done quite well virtually, in my opinion. And you get a decision usually within 24 hours after the hearing ends, and you get a reasons for decision within 4 business days. So the reasons is different. It's the justification for how the board came to their decision, but it is quite rapid. And in my experience, I've had cases or CCB files that, in terms of the shortest I've had, about a month with a 1-day hearing. And the longest was this case that I had, which was basically 8 days and being cross-examined for approximately 10 hours. So it can vary from case to case. And the CCB has heard more end-of-life cases than all Canadian courts combined. So I think it's actually, we're actually quite lucky here in Ontario to have this. And I'll talk about that a little bit further. So the CCB is an independent, neutral third body that is quasi-judicial. It'll come to the hospital, as we already mentioned, and it'll decide what's in the patient's best interest based on Section 21 of the Healthcare Consent Act, which I'll highlight a little bit later on. The patient will have a lawyer assigned to them from the Consent Capacity Board. It's up to the SDM to seek their own legal counsel. If they can't afford one, then you can provide contact information for legal aid. It's not required that they have legal counsel, but I highly recommend, and so does the CCB, recommend that they do have legal counsel. And it can actually result in delays if they don't have legal counsel. So if you ever go through this, please provide them with the information for legal aid. So the CCB hearing itself, there's 1 to 5 people on the board. From my own experience, I've had either 1 to 3 people on the board. There's one person, the chair of the board, who will preside over the hearing. They're a lawyer member. And the other individuals may be lawyer members or members of the public who are part of the CCB. And as mentioned, the hearing can be adjourned if there's no legal representation for the substitute decision maker. Much like a court-like case, you will present your case, you call any witnesses you would like, and hearsay, unfounded or undocumented information is allowed. And then you and your witnesses will be cross-examined. Subsequently, the substitute decision maker will present their case, call any witnesses, and are open for cross-examination as well. Hearings usually last all day. It can be from sort of 9 to 4 p.m. and in fact longer, depending on the complexity of the case and people's schedules. Physicians can actually be compensated for their time, about roughly $1,200 for any case over 3 hours, and I think it's about $400 for less than 3 hours. And you get a decision via fax or email within 24 hours, and my experience has been the same night in some situations. So, as mentioned, the CCB will decide whether or not the substitute decision maker is acting appropriately. And before a substitute decision maker can be enacted, you actually have to first prove that your patient is incapable or cannot provide consent. And obviously, in this situation, this is an article from the CPSO, which really focuses on dementia. You have to prove that your patient cannot consent. And the summary of that is you have to prove that they cannot either understand, appreciate, or communicate a treatment decision. And these are some of the questions that you might be able to tease out and answer. And today is not a talk on how to determine capacity, but it's ultimately up to the physician to decide whether or not that patient is capable. And you have to prove those 3 domains: understanding, appreciation, and communication. Okay. And if someone is incapable, which, to sort of not cut corners, but I would say the vast majority of our patients in the intensive care unit are incapable because of how extreme their conditions are. So if they are incapable, you need to document the date, the finding of incapacity, and the reason for your decision. So we may have a 25-year-old male who's involved in a motor vehicle collision who has severe traumatic brain injury, and that is the reason for their incapacity, because they are in a comatose state and cannot communicate with us and are unresponsive to any sort of stimuli. That would be a very straightforward note that I would write in the chart. And just remember that capacity can fluctuate. So you have to test capacity over time. And if it is for a mental health reason, which I rarely deal with, they have the right to challenge you, and you must provide them with a Form 33 and a Form 3, and they will have access to a rights advisor. I rarely deal with that. I do not know much more than that, but I did feel like I needed to mention that for today's talk. So once your patient is deemed incapable, you now need substitute consent. So the first thing I teach residents, both on my internal medicine service and critical care, is during the admission process, you should always be asking if there is a living will or a previously expressed wish or a signed power of attorney document. The reason this is important, as we'll get into shortly, is the substitute decision maker needs to act on previously expressed competent or capable wishes. And this is a very straightforward question to ask, and it's part of information gathering. It is non-confrontational, very easy to do, and should be part of your checklist when you're admitting a patient. So now that you've deemed your patient incapable, you need to correctly identify the SDM. I find this is something that's done quite poorly for those that are inexperienced from it. And luckily, the Healthcare Consent Act lays out a hierarchy of substitute decision makers. The first is guardian. In the adult world, we rarely deal with guardians. What we deal with quite often is attorney for personal care. Now, this is important to tease out for the healthcare team because a lot of substitute decision makers or family members may get this confused with other things. So power of attorney for finances, executor of the will, whatever it may be, real estate. So the key here is to ask them to bring in this document as soon as possible to have it on record that says, I am the power of attorney for healthcare decisions. And the reason as well this document is important is because usually what's attached to it are potentially some advancce directives from the patient themselves. Third is a representative appointed by the CCB for spouse or partner. Just what a word of, not caution, but just teaching. Partner can have a variety of different definitions. Involve your social worker to help with the definition of partner. To give you an example, partner can even be a non-family member or non-intimate partner, could be even a neighbor. As long as they show investment in your health and caring for you, they could be considered a partner. Child over the age of 16, I do not know why they have to be over the age of 16. Parent with right of access, brother or sister, any other relative, including in-laws. And then if there's no one, then you have to go to the office of the public guardian and trustee. However, they're only open weekdays during certain hours of the day. So the role of substitute decision makers as well is that they, just like your patient, they must be competent, they have to be willing, and they have to be available. So there is nothing wrong with a partner saying, or spouse saying, you know what, I am uncomfortable making this decision, and they can abstain from making their decision. It would fall to the next person in the hierarchy. What they cannot do is appoint someone on their behalf, right? So if they abstain, they cannot say, I want my son Jim to be, or my daughter Mary to be the substitute decision maker. It would go to whoever's next in line. And if there's multiple people, like for instance, in terms of children, they would all have equal substitute decision-making capabilities. And if they don't agree, then it would go to the public guardian and trustee. So their role, this is very important, their role is to consent to a treatment plan proposed by the medical team. Their role is not to demand therapy. They must act on previously competent expressed wishes. And if there's no clear wishes, they must act based on values, beliefs, and best interests of the patient. So that comes from Section 21 of the Healthcare Consent Act, which is laid out here. Referring back to my case right now, our patient was incapable. You can imagine being intubated on a background of dementia and being on sedative drugs would deem someone incapable of consenting. What I did was early in the course of this patient's admission, I sat down with, well, not sat down, but I spoke to the substitute decision makers on the phone. And I had specifically asked if they ever had the opportunity to discuss being very ill, close to death, anything sort of very critically or critical situation in their life. And their answer was no, they never had the chance to discuss it. So assuming that has been satisfied, then you ask about basically best interest. And what best interest entails are the values, beliefs of an individual, and as well their physical, mental, emotional, spiritual well-being. So there's lots that goes in there. And some of the things that I teach when asking about values is to start with very open-ended questions. Mrs. Johnson, can you tell me what your husband values in his life? I start with that and then sort of grow from there and ask more detailed questions. Do they value being at home, being independent, being able to interact with family members, walking, talking, eating, toileting? What would they say if they were here right now about their situation? I try to open it up as much as possible. Another helpful question is, have they ever seen someone who's been critically ill or close to dying, and do they understand what these types of interventions are? So I'm obviously skipping through a lot of the details here today for the sake of time, but those are some of the sort of, in my opinion, some of the initial questions that I ask that you can gain a lot of information from. So now that we've hopefully identified a substitute decision maker and they're the legally correct substitute decision maker, and hopefully have identified the presence or lack thereof of previously expressed wishes or a power of attorney document, and we've divulged into or gone into what beliefs and values are, it is now time for us to propose a treatment plan. And as mentioned, our treatment plan in the ICU, in this case specifically, was withdrawal of life-sustaining treatments. And if those treatments or if the patient was already liberated from the ventilator, then our treatment plan would be no escalation of care back to in the intensive care unit, no CPR, no artificial means of feeding, and no escalation of care or resuscitation, which was the case for the patient that I presented earlier. So once we presented that treatment plan to the substitute decision makers in writing, it is then up to them to say yes or no to that treatment plan. If they say yes to the treatment plan, clearly you'll proceed with a palliative care plan or that plan that we've suggested. If they say no, and we still believe that's the best plan for the patient, then we proceed with an application to the Consent and Capacity Board of Ontario. So that brings us to the next process, which is actually navigating the CCB process, which can be quite challenging if you've never done it before. It's actually pretty straightforward. Now, as Dave mentioned, I've done this over a dozen times. So the first thing you need to go to is the Consent Capacity Board website. You download what's called a Form G, and this Form G will be faxed to the board. They will then set a preliminary date, and on that Form G, you have to have the substitute decision maker's name, contact information, usually email and phone number will suffice. And we usually deal via email about setting up a preliminary date. And it's usually phone at first or virtual. And if you do have a physical date, you have to book a room if they do it in hospital and provide directions. The most challenging part for the healthcare team, and namely what falls upon the physician, and this is why, frankly speaking, a lot of physicians want to avoid this, is you now need to create a case summary. And you can imagine when someone has been in hospital for weeks, in fact, in most cases that we've taken, it's months to a year or so, summarizing that case and collating all the notes and providing submissions can be quite onerous and takes up a tremendous amount of time, especially because you need to label each individual submission A, B, and C, create a table of contents, and highlight what's in your submissions. So it can be quite a bit of work to do. So are there issues with the Consent Capacity Board process? Yes, there are, in my opinion. From the time of application to decision is at least 1 month. That's my shortest sort of, as mentioned earlier, my shortest case. It can take months. And in fact, after the CCB application, or CCB decision, excuse me, the substitute decision makers have the right to appeal to the Superior Court, which can delay things even further. And in this case, which I don't want to have any spoilers, but the family decided to appeal in this situation as well. Personally, the decision is solely based on law and has no regard for either medical standards of care or ethical principles. And what we did in this situation and what happened in this CCB case in particular was the issue of artificial feeding. So they tried to, the substitute decision makers and their counsel tried to argue that either feeds from ourselves or TPN or any sort of nutrition in the hospital setting was not a treatment, and therefore the Consent and Capacity Board had no jurisdiction over it. Our job was to argue that it is actually a treatment, that we prescribe the amount, the rate, the composition, and have to monitor for complications and benefits of that nutrition. So the Consent and Capacity Board in this situation decided that yes, it is a treatment, and yes, the CCB has jurisdiction over it. Hearings can be quite long. Prep time is even longer. I was cross-examined for, I think, 8 to 10 hours in this case, over the span of 2 days. And can this result in litigation for the physicians? Yes, it can. There's no doubt about that after the fact, and can make it seem like a never-ending process, especially when there's appeals, complaints either to the college or a actual suit that comes about, or statement of claim. And then from a legal representation from the physician, I have represented myself in certain cases. I've had representation from the CMPA, and there was one case in particular where the CMPA, for a variety of reasons, did not want to provide legal advice in that, our representation in this case in particular. So the hospital, our hospital, was kind enough to retain a independent lawyer that provided me with legal representation during this case. So getting back to this case, and I'll show the highlight in a moment here, but in this case, the consent capacity board found that the substitute decision makers were not acting in accordance with Section 21. So there were no previously expressed wishes that we were aware of. And as I mentioned, I had that discussion with the substitute decision makers earlier in the course of the patient's admission, and documented, luckily, in the chart that there were no previously expressed wishes that I was aware of. This is important to document as early as possible in someone's admission. The reason being is there was quite a bit of contention about previously expressed wishes during the actual hearing, because I presented my phone conversation, at which time the SDM said there was no previously expressed wish. And fast forward to the consent capacity board hearing, where the substitute decision makers were then saying, yes, we had multiple conversations. She had previously expressed wishes. As mentioned, so the SDMs were ordered to comply with palliative care. They appealed to the Superior Court, which delayed the process by months. The appeal was subsequently dropped, and unfortunately, the patient subsequently passed away, but with no escalation in care at that point. Here is the actual, just the one sort of screenshot from the reasons from decision. So what you'll see is that the result of it is the panel determined that the patient was incapable. So that's the actual first part of the hearing, is I need to prove that a patient is incapable. So I performed multiple capacity assessments, and it's wise as well to potentially get a second opinion. Where this may be helpful, sometimes if you're more so on the internal medicine side of things, and you're dealing with the patient who has cognitive impairment, it may be worthwhile getting a neuropsychology assessment. They can offer a second opinion about someone's capacity. In the ICU, as mentioned, rarely do you need that, because people are generally speaking quite incapacitated from their illness. But if you are working on an internal medicine ward, you may seek an opinion of a neuropsychologist, a geriatrician potentially. Psychiatry are not there to deem someone capable or incapable if there's no mental health issue. So I've seen people reach out to psychiatry to say, hey, can you determine whether this person is capable? And the psychiatrist will appropriately say, well, is there an underlying mental health issue that would affect their capacity? And generally speaking, in my experience, the answer is no. But you can ask anybody else for a second opinion with regards to that. You should as well not probably, according to the CPSO policy, you should seek a second opinion from an independent physician and an ethics consultation as well. So Dave had mentioned earlier that I'm part of our advanced care planning team here at the Ottawa Hospital, and part of our team includes ethics, a second physician, potentially a disease-specific second physician. So if you're dealing with someone with a stroke, we have a neurologist involved, we have geriatricians involved, nephrologists, if that primary issue is in their domain. And we also have social work, patient relations, and if required, legal to help us out in terms of our advanced care planning team. So this is taken from the CanLII website that I showed you earlier. And you can look up any case that's there, and they will give you the reasons. If you're have an interest in these, much like I do, I tend to read around these cases that come out. Since the CPSO End of Life care policy has been modified, based on recent case law, to say that we do not need consent to withhold or not initiate resuscitation, I have not done a consent capacity board hearing since then. The reason being is we are quite good at identifying these difficult cases quickly during admission, and this allows us to sit down with family members ahead of time and provide our reasoning about why we would or would not offer resuscitation. And I find personally, and I'm biased because I'm one of the co-founders, I've found that this has helped with communication quite a bit. It is in a non-rushed, non-urgent setting, as opposed to an ICU consult or a critical care outreach team consult where someone is in distress. You're having a conversation that's limited by time and a stressful situation and urgency. And by having this advanced care planning team, we've managed to identify these individuals earlier, communicate with families, and I find it's helped tremendously to help them understand our reasoning behind why we wouldn't offer these things. And I think I'm at about sort of 22 minutes there. Maybe what I'll do is end it there and see if anybody has any questions, comments, or any cases that you've had. I'll leave it up to the question and answer panel.
Thanks, John. A lot there. And I'll go to start with Dr. Lawless in a minute or two. I'm curious, you said hearsay is allowed, so it's not to the same extent as a court, I would presume, and that it is, for want of a nicer word, more liberal in what it invites. Is there ongoing discuss like if someone says stuff, do people challenge it, or how what is the process when you're actually in there in that regard?
So I will I'll comment on a case that I had, a separate case. Around the time of COVID, there was an individual with advanced COVID. We had tried everything, months in hospital, deteriorating, and there was a family meeting held between myself and the family, witnessed by a social worker, and the family had actually recorded the conversation. And there was a dispute between what the details of that conversation were, and they refused to release that recording. So not that it was hearsay per se in that situation, but it was my word and my documentation versus theirs. There's also situations where you will have a hallway conversation where it's not documented in the chart that you would refer to. And that hasn't happened to me, but did happen during one of my cases with a separate physician that we would rely upon, but we could not prove it because you can imagine retrospectively going into the chart, documenting something is a no-no. So that's what I mean by sort of hearsay in that situation, at least in my experience.
Okay. And what has been the lasting consequences as well? You talked about litigation and complaints. I'm sure that scared off a bunch of the listeners, but what were the, like, how does the college deal with this? Or, you know, for someone like yourself with a dozen, I suspect it's, you know, hello again, but are there lasting consequences and any advice for individuals?
So not to make light of the situation. So there's consequences for the physician. There's also, obviously, I don't want to come across as heartless or not thinking about the other side of things as well for patients and while they're substitute decision makers and their loved ones. There's consequences for both. From a physician side of things, I've had college complaints. Luckily, what I've relied upon the entire time is my documentation, which has been extensive in these situations. So from a college complaint perspective, there's been no finding of wrongdoing in my situation because the documentation has been excellent. And more importantly, what we've lost, I get a little aside, what we've lost with our electronic medical record is the nurses' documentation. When we had a paper record, the nurses were providing a narrative multiple times throughout their shift. And that was tremendously helpful in me building my case for these CCD situations and for college complaints. Now that's almost impossible to find on Epic in our ICU. The bedside nurses outside of the ICU still do a narrative, but it's very difficult to find in our ICU. From a patient's perspective, or excuse me, a substitute decision maker or loved one's perspective, they've written either news articles or had interviews about their lasting effects, which can be quite stressful and quite difficult for them after the fact as well. So it affects both sides.
Interesting. I'm going to go to Dr. Lawless.
Great. Thanks, Dave. And thank you for that very good presentation. I think many of us have been in situations where we might call upon the CCB and either end up not having to follow through on it, or we perceive some of the challenges or barriers, and that kind of wards off, I think, some folks around that. So it's good to have this outlined as clearly as you have. One of the questions I have is, I know that most sites usually have a rotation of who's on staff at any given week. And this obviously, the process sort of extends beyond, you know, your single week in an ICU. And how have you managed, or how have you addressed or anticipated the being involved in this with something that's going to really carry over across your time in the ICU, and how did that work with your colleagues?
So this process has evolved tremendously over the years. I am fortunate enough to work with a great group here in Ottawa, minus Dave. But besides him, our group is very reasonable. And what we created and what we've done is we have monthly site meetings. And part of our agenda for our meeting are difficult cases or end of life cases. And we form this as a group. Our treatment plan is vetted by the group, and that we are unanimous in what we are willing to offer or not offer. That way we're all on the same page. We have the same message delivered to the family. And we never did that in the past until we were faced with these difficult cases. So and in fact, I've been called out at the consent and capacity board by legal counsel for substitute decision makers or patients that I'm a lone wolf and that I am the person who's always doing this and that you have an agenda. That is not the case. And I bring this up at the CCB that we actually discuss this as a group. And because I have the most experience and because we're a group practice, this is why I'm always at the CCB and not potentially one of my colleagues. So.
Good. The other question, I mean, you have these conversations with families and you can almost feel as empathetic and sympathetic and collaborative as you might try to be. When you get to the point of maybe going to CCB, there's always a sort of like tension. And I expect or anticipate that then you pull this trigger of going to the CCB, that sort of deepens that tension. Is that how has that kind of manifested, and how do you manage that with the family?
So you can, frankly speaking, say goodbye to the therapeutic relationship that you had with that individual previously or individuals. Becomes honestly highly contentious. There are pretty harsh words spoken, at least to me. I've had newspaper articles actually published as well, so that can happen. It has gone to the news, and sometimes I'm mentioned directly, sometimes I'm not. So that has happened quite a bit. What we usually end up doing then is communicating through legal counsel, through email, for the most part, between the each party's counsel after that. So it unfortunately can deteriorate the relationship quite a bit, and there's a lot of hostile feelings, to be frankly honest.
Thank you.
Thanks, Bernard. I'm just going to go to Jennifer and remind those with questions to submit them to Q&A. Jennifer?
Hey, thank you. Thank you for the talk. I have a few questions from the participant. The first one is, what do you do in a situation when you believe the patient is refusing treatment, is incapable, but the SDM is still proposing full resuscitation?
So the patient is incapable and they're refusing treatment. So the tough question, I mean, without a little bit more context, but if the patient is incapable at that point, you have to defer to the substitute decision maker. I've had that situation many times where a patient is, at least in my situation, pushing things away, saying, no, I don't want this, pulling things out. But they're clearly not capable in that situation. You still need to seek consent from the substitute decision maker in that situation. I try to appeal to them to say that, it's clear to me that they don't want this by their actions. However, they will say, no, when he or she was with it, they would want everything. We know them, they're a fighter. And that's the usual response that I get in that situation. So unfortunately, you still have to approach the SDM about any sort of treatment plan.
Thank you. Now, earlier you alluded to when you were discussing with Bernard about how your division is very united. You discuss care plan, but there might be unit that perhaps there will be one or two members of the division who might not be agreeable to the CCB application. However, the majority of the group is supportive of such CCB application. How would you advise this group who might want to submit a CCB application? However, they're worried that one or two of the members might not be supportive.
Yeah, I would appeal to those one or two members saying that I think it's speaking of standard of care, I think it would meet the standard of care. It's referred to in the CPSO End of Life care policy. The role of the CCB exists exactly for this. And more importantly, I'm always going to bring it back to the patient that's there and us advocating on behalf of the patient that we think it's the best thing, the best treatment plan for that patient. And I've been quite vocal about this, and obviously you can ask Dave that I encourage us to use the CCB as much as possible when, at least when the CPSO policy was its old policy. So for those reasons specifically, we follow the CPSO policy. I think it helps as well, to be honest, and I'm not doing it to be defensive, but if we ever did receive a college complaint, we can say, we have followed your process to a T. You recommended the consent capacity board. We went to the consent capacity board. We notified, and one of the important things to do as well is always notify the family about what the CCB is and that you'll be approaching the CCB, so it's not a surprise to them. And that I don't want to say forewarn them. I usually mention it early on, is that there is an independent sort of body that exists that can help us resolve this. I prefer not to go to it myself. I'm hopeful that we can reach a decision together. But if we can't, sometimes we have to go to, and I refer to it as sort of mediation, right? We're going to put this in someone else's sort of court, I guess to use the term, and let them make the decision for us.
Well, thank you. Another question that the audience had asked is, you mentioned about legal counsel to assist, and it's a team effort to put an application in. Can a hospital legal counsel be brought in to assist in actually putting together the CCB application, or is it mainly conducted by or led by a physician?
It's mainly conducted by the physician. So you have to recall, like in the majority of my cases, my legal representation was from the CNPA. The hospital has been incredibly, at least our hospital has been incredibly supportive of our applications to the CCB, but their legal counsel is obviously for the hospital themselves. Whereas us as physicians, most people would be aware as physicians, the CNPA is our legal counsel. They will tell me and help me decide what enters the case summary, but ultimately to collate all that information, it falls upon the physician to do most of that, because you're the one who's going to be the lead for that application. So, and that's hopefully in the future, we can maybe find some administrative help to potentially help with that, because that, like I mentioned, can be quite onerous. Like you're printing out the chart, you have to get everything together, and it could be 3,000 or 4,000 pages of chart, right? It can be quite extensive. So unfortunately, it's going to fall on the physician.
Dave said, okay, I will continue. I have a few more questions. Yeah.
We'll go one more and then we'll go back to Bernard. So
okay.
Excellent though.
I'll do one more. So there's a case that a participant had put forward. In a case where an elderly patient who no longer really require ICU care, they just needed long-term ventilation, but the SDM wouldn't consent to application to transfer the person to long-term ventilator center, or would they consent to palliation? Is this something that the CCB could be helpful, because the SDM is not willing to consent to either of those options?
Yeah, it can be. So again, I'm not a legal expert, but I've gone through this a couple of times. So the key here is it's depending on what your hospital policy is and what the institution is as well. So getting someone to long-term care, you still need consent to get someone to long-term care. To get someone to a different hospital that the treatment remains the same is just a change in environment. So in my opinion, I'm just speaking on myself, and a lawyer may say, Dr. Adhikari is completely crazy, has no idea what he's talking about, but transfer to a facility that provides the exact same care and no different treatment would not be considered a treatment, in my opinion. Therefore, consent would not be required, in my opinion, from the substitute decision maker. You're just changing the physical location. Same applies in the analogy I use is if you did have a chronic vent bed on the ward, which we do at our facility, transferring from the ICU to the ward does not require the substitute decision maker's consent. The same thing would happen. Same treatment would happen. We're not withdrawing anything. We're not changing anything. So that would be my argument.
Yeah. The participant said that the facility actually requires consent. In this case, then you will have to go through the process. If it's indeed they require consent, yeah. Thanks. Over to you, Bernard.
Okay, great. Good discussion. I'm really enjoying it. The one question that I had that's submitted is regarding to the mention of the ethics board from the hospital, and what is their role really per se in terms of any, I guess, what do they lend to the process, but also when would you suggest they get engaged?
I would suggest they get engaged in all of your difficult cases. I see no harm. I only see benefit to having them involved. Again, it's mentioned in the CPSO policy to potentially have them involved in your cases. In my case, they've been they're obviously not there to pick sides or say who's right or who's wrong. They offer a chance for further education for the family and potentially independent education for the family, because they are well versed in sort of the Healthcare Consent Act and principles of substitute decision making, and can help as well sometimes tease out values and beliefs that potentially were not addressed by the physician or the healthcare team previously. So they've been useful in the past, and forming potentially a therapeutic relationship with the substitute decision maker as well.
Okay, that sort of lends into my next to the next question that was submitted, and that is around SDMs and challenges I think that the capacity board may have encountered if the SDMs weren't properly educated about their legislative responsibilities as an SDM. And so is that still a concern, do you think, from the CCB about ensuring, and what I guess has to be done to ensure that the SDMs actually know what their responsibilities are and how that's demonstrated before you go to CCB?
Yeah, so as part of our advanced care planning team, some of the things that we do is actually provide them with Section 21 of the Healthcare Consent Act. And we, in layman's terms, tell them or educate them about what their role is. And I tell them, like, the reason you're a substitute decision maker, or the way you're supposed to act as a substitute decision maker, is if you've ever talked about this before, or if there's any previously expressed wishes. And that I use that as a lovely segue to say, you know what, do you have a living will? Have you ever talked about this before? And then if you haven't talked about it, you need to act on their best interests. And that's when I get into values and beliefs. So I do educate them ahead of time. I will also provide them with the CPSO End of Life care policy. And as well, as the advanced care planning team, when they will actually ask, and family members have asked, well, do you have a legal right to do this? Say, well, we don't have a legal right per se. We have case law, and I'll actually provide them with the reasons for decision from that case. And some people have actually read it, and after the fact, a couple of days later, have said, "Oh, you know what? This makes sense. I've read your policy, and I've read this sort of reasons for decision, and I have no further questions. That makes sense to me." And some people actually feel relief from that burden of they are trying to uphold either a religious belief where they must do everything to their religious community or their religious beliefs, saying, but they will not consent to not receiving CPR, but they'll at least say, you know what, doctor, I'm happy you took that decision out of my hands. I'm happy there's a justification for it. And I feel relieved that I can still say that I've requested everything from my loved one, but ultimately the decision is up to you and the healthcare team. So that's some of the experience I've had as well.
I think that's an important point to make, because I think oftentimes conversations are held with the family and they have this huge burden on their shoulders. Like, they are going to make the decision that their loved one is going to die. And that's a very difficult thing for families or loved ones. And I feel sometimes if that burden or that weight can somehow be removed from them, they know that their loved one will probably pass away, but it may happen then without them actively making a decision about it. And that's, I think, if of my 20 some years of having these conversations, I think something I've learned, how you navigate that. And people feel relieved sometimes when that decision part is taken away from them, or the rationale for that decision, and they understand what's going to happen subsequently. So that's a good point for you to be able to make. And that's it for questions I have on this side. Dave.
Thanks, Bernard. I mean, that last point is something we all have our own style and approach. And, I always try to emphasize you're not making the decision, does mom or dad or brother, sister, husband lives or die, that you're giving us guidance on what's important, what they value, and what they would want in turn, or would they accept? As I said, I always hate the word want because no one would want any of it. What are they willing to accept? So is the point. And just to emphasize that when we have these cases, Gianni certainly is the lead, but we do discuss it as a group. And there's times where there's dissension, and I don't know if dissension is the right word, but we always go to what most would be, are comfortable. So if some are advocating a little bit more advanced or something, we all work together as a team, and it has worked quite well. I'm going to go to a final question with Jennifer, and then I'll get Dr. Lawless to sum it up.
Thank you, Dave. So one last question from the audience. Gianni, could you comment on the role of the CCB given the new CPSO policy that you have alluded to earlier on end-of-life care? How should we select the appropriate cases that will be covered under the end-of-life care of the CPSO policy? And presumably, would it be vented patients with a prolonged anticipated survival and ongoing suffering?
Yeah, I think you'd probably answered the question right there. I still do think there's a role for the CCB. I have not had a case, as mentioned, since the policy has changed, because unfortunately, how sick people are in the ICU, they're subsequently going to pass, because we can say, you know what, they did not come in on vasopressors, which are obviously drugs to keep the heart and blood pressure going for those that are unaware. And if they do require that, I won't be offering that, because that would be ongoing resuscitation. So the patients have subsequently passed before there's time to actually even go to the CCB. I'm sure there would be a case at some point where someone is going to be quite stable for a period of time, and that's where I would advocate using the CCB in that case, where they are vented and would potentially survive for weeks to months on the ventilator, and I think that would be a good case for the CCB.
Okay, back over to you, Dave.
That's great. I just want to remind everyone to please take the time to fill out the survey. There's a link in the chat right now, and you'll be sent a link. Gianni, despite what I know about you, I appreciate you did an excellent job, and I do think people out there who have questions, I don't believe anyone has done as many CCBs as yourself, other than some of the lawyers with it. And so you're a great resource, and I'm sure you'd be happy to talk with individuals who want to reach out. So I'm just going to pass on to Dr. Lawless for the final comments, and happy to say thank you one last time to the staff.
So thank you, Dave. And Gianni, that's high praise consideration of coming from Dr. Neilipovitz, in case it wasn't quite quite veiled that way. Thank you very much for your time today and for agreeing to do this presentation with the OC3PR. I think this is something that we don't really get sort of a lesson in per se. And it's something that many of us practicing in critical care are probably a bit shy of proceeding with. And maybe sometimes with unfounded sort of fear or concern. I mean, it is a lengthy process, as you sort of outlined. And so thank you for doing it as often as you have, because I'm sure it's taken a few added perhaps to maybe some gray hairs that weren't yet coming in. And it really is valuable, I think, for the rest of us to have learned or heard of this experience that you've had, and some of the ways to navigate the process so that it is I think especially it can be seen to be done with the right intent. This isn't something that we do, I think, with just because to be counter to somebody or have a counter opinion, or that the family is being difficult. It's done with a lot of thought, and really keeping, I think, the patient at the center of focus in terms of what might be reasonable or best for the patient. So we really appreciate your participation today. We appreciate all of your discussion around the questions, and I think, as Dave has mentioned, I think because your experience in this, I think, is valuable. You probably have other lessons to highlight, and if they want to contact you through us, then we'll gladly pass that along. But thank you again for your time. Thank you to Dave and the committee for the organization that goes into this. Thank you to the CCSO team for supporting the technical and operational time for this. And I hope everybody has enjoyed the discussion.
Thanks, everyone.
Thanks again, G.
Anytime.